If you really wish to kill your startup and destroy your own personal wealth as a startup founder, then only in that case you should sign an agreement which has an indemnity clause. Now, the term indemnity actually might sound like a legal term, but in simple terms, what it means is that in case there is a wrongdoing, then somebody has to compensate for it. Which simply means that indemnity by itself is not really something wrong. But in a startup fundraising transaction between a founder and an investor, it can become a problem in case there are certain additional clauses entered into that. And it is actually pretty common for larger investors to have certain tricky indemnity clauses. For example, they can have joint and several liability in the indemnity, which means that if there are 2, 3 co-founders and one co-founder does any wrongdoing, then all of them are jointly and severally liable. Also, such clauses generally also have an unlimited liability for an indemnity, which means that there is no cap, which means that if some co-founder did something else, then the other co-founders can be held liable. And not just that, they can be held liable for unlimited liability, which means that there is absolutely no cap as to how much money they have to pay in compensation. And that is why it is highly recommended for you to seek legal advice before entering into any agreement with your investors. You should be in a position where you understand every single clause of the agreement and the risks associated with it. So that was the legal insight for this video. If you liked it, consider following, because you will see a lot more legal insights going to be delivered by me in the future.